This next vignette shows a lawyer preparing a witness, his client, to give a deposition in a case. And the case involves a dispute about coverage under a $10 million fire insurance policy. And as with so many of the vignettes and the examples that we've used in this program, this one is based upon a real case. And what happens is, on day one, Robert Williams, who has just bought the building in question, calls Bill Siegel, who is the agent for the XYZ insurance company, to get fire insurance coverage on the building, and he's looking for coverage in the amount of $10 million. At the end of the call, Siegel agrees that the XYZ company will cover the risk. He prepares a binder and he sends that to Williams, the new owner. There's a fire the very next day and the building is destroyed. And after a bit, the insurance company denies coverage, and it denies coverage because it says that Williams told Siegel, the insurance company's representative, that there were sprinklers, there was a sprinkler system in the building, and that the system was operative. It was operating, so if there were a fire, system would go on. And, says the insurance company, in fact, while there was a sprinkler system there, it was not operating. And so when the fire occurred, naturally, the sprinkler system did not go on, and hence the building was destroyed. That's the insurance company's side of the story. And about a week ago, Bill Siegel gave testimony to this effect on behalf of the insurance company, and he said very confidently that he was told by Robert Williams that there was a sprinkler system in the building and that it was operating. Robert Williams is an honest witness, as his lawyer sizes him up, but his recollection of the conversation that he had with Siegel is not very sharp. He recalls that, yes, they did speak about sprinklers, but he can't remember very much more. A lot was going on at that time. It was a hurried conversation. His objective was to answer the questions, get the coverage, and move on. And so this next vignette will show what this lawyer did with this witness in order to prepare him to give the most positive testimony that he could on his own behalf.
Robert, let's talk a little bit about the insurance issue. You recall that on October 13th, you and Mr. Siegel, the insurance broker, had a telephone call. Do you remember that?
Yes.
And what did you tell him you wanted? Fire insurance?
I told him that I wanted fire insurance, and so he asked me how old the building was, and I told him that it was the particular age of the building, which is why I wanted fire insurance.
Okay. Did he ask you any questions about how big, how many floors?
He wanted to know how the building was being used, and I told him that it was previously used as an office building, but it was vacant currently, and we had a plan to turn it into a trendy upscale place for kids, and that's what I told him.
That's your memory of the conversation right now?
Okay.
Yeah. Did he say to you, it's important that you answer his questions truthfully?
Well, he didn't say that, but I knew that you can't lie to the insurance company and then collect on the policy.
So you knew that it was important that whatever you tell him was correct and true?
Yes.
Okay. Now, what did you know at that time, that day, when you were talking to him on the phone? What did you know about the sprinklers in the building?
I didn't know much. As far as I was concerned, I could see sprinklers throughout the building when I walked through it.
You saw the piping and all that?
Yes.
Okay. Did you know whether they worked or not?
No, I didn't know because I wasn't concerned with that when I was walking through the building.
Why not?
Before I purchased it. We were going to tear out the sprinkler system anyway before we started the rehab work.
Okay. So, do you remember whether he asked you in that conversation whether the sprinklers were working?
I know that he said that he did, but I don't think he did. But I can't
You mean you're
recall.
referring to his deposition where he testified?
Yes, and when he testified at his deposition, he said that he mentioned that to me, but I can't recall that.
Okay. Do you think that if he had asked you that question, what would you have told him?
I would have told him that I didn't know.
And what would you have done about that if he said, I need to know whether they're working?
I would have told him that I would have had to have somebody go over to check.
Okay. Now, why would you go through all that? Why wouldn't you just...
Well, I would be worried if I didn't have fire insurance because the sprinklers weren't working.
So you knew you needed, if you didn't know whether they were working and he wanted to know that, you had to find out.
Right.
Okay. Now, let's talk about after the fire. The fire happened the day after you had this conversation, is that right?
Yes.
Now, so how did you find out about the fire?
Well, I was on my way to the airport and I got a call from my general manager and he told me that the building was burning down.
Was that pretty upsetting to you?
It was. I was upset. I was hoping that nobody was injured.
Right.
And there were no injuries. But I was sad to literally see this place go up in smoke and our plans for it.
Now, did you think about the fact that you had fire insurance?
I thought, thank God we have fire insurance.
Did it concern you? Did you have any thought about the sprinklers at all at that point?
No, it didn't cross my mind.
And this is the day after you had your conversation with Mr. Siegel.
Yes.
So, in the deposition, you're going to be asked, for sure, did you talk to Mr. Siegel about sprinklers? Okay?
Okay.
When that comes up, do you now remember the conversation you had with Mr. Siegel?
Now that we put it together, I think so.
Okay. Well, do you remember it, or do you just, we've put it together that you've concluded from our conversation?
Yeah, I think from our conversation, I can put it together and conclude that I can't recall that he said that to me.
Okay. Now, the important thing in the deposition would be that you explain why it is that you believe that you did not tell him that. You understand that?
Yes.
Because you don't really remember the conversation, do you?
No.
Okay.
Dave, how did you react to John's job of preparing the witness here?
Well, I thought it was a particularly good demonstration of what I think is the appropriate way to have prepared this witness. Unfortunately, a lot of lawyers wouldn't stop or conclude as this vignette demonstrated. A lot of lawyers would have tried to convince the witness that the witness actually had memory, that by walking the witness through the logical sequence of what must have happened, try to convince the witness that that in fact happened and create memory rather than reconstruct actual memory. And the creation of memory, where it really truly doesn't exist, is both ethically and strategically an error. It's ethically obvious that you don't want to tell a witness and encourage the witness to have memory that he in fact does not have. But also strategically, it's a disaster for a witness like this to show up at the deposition and have a pretend memory. A good deposition taker will expose that readily. And then the witness who had an otherwise valuable case now has a case which is worthless because it's demonstrated that the witness is in fact giving false testimony. So stopping where you did at helping the witness piece together what probably happened or what even must have happened, but then telling the witness clearly that the witness is going to have to explain what his thought processes are in this case, that what he's doing is putting together that logical sequence is so critical. It's such an important technique difference between the proper way to do it, as you've just demonstrated, and the unfortunate way that some lawyers would do it and run the risk of losing their whole case because of it.
John?
Well, I think I agree with that. And to me, you really, it's all about being an advocate for your client so that you can present the case in the most compelling and believable way possible. And if a witness can explain how it is that he has testimony that something did or didn't occur, it's always better than if he just sits there and says, no, I did not tell him the sprinklers were working. And as David said, he's going to get picked apart on that. But by helping him remember what the logical basis of his memory, or not memory, but his position is, you have a more credible position. Whereas I think the Mr. Siegel in that is going to say, he probably has 10 of these conversations a day. And for him to say, for sure, I remember asking him if the sprinklers were working is probably more likely to be that's what he usually does. And we can put together a scenario that shows that in this case he must not have done that, because Robert would certainly have told the truth, because he's a looks like a credible person anyway. And so if he's asked if the sprinklers work, it's likely he would have said, I don't know. And then they would have found out the answer to that question. So I think the ethics are important, but it's also it's just better trial advocacy if your client can come across in a truthful way that is understood and the jury can relate to it.
Yeah, I had a witness in a case one time, a very bright, able fellow whose the state of his recollection was somewhat stronger than Robert's was here. But if I transfer him to this case, the gist of the testimony would have been, I did not tell Mr. Siegel that the sprinklers in the building operated. I'm confident of that. Now I have to tell you that I'm not 100% sure that I remember that. I'm not sure that I'm not backfilling some, because I know that I would have told him the truth. I know this, I know that. So he stated it as positively as he could, and he was being truthful. He thought he remembered not saying it, but he at the same time acknowledged, I might be doing that. And I think in that case, it was an arbitration case, and I think it was pretty obvious. The arbitrators believed him because it was a very, it was the way people often remember. I think this is the time in law practice where you are really, your mettle is really tested. And the reason for that is there are two people in the room usually, you and your client, and you both want to win.
Right.
And so...
And you know how.
And you know how.
Right, yeah.
And the client can figure out how pretty quickly.
Right.
And and so you really do have to check yourself and use your moral compass. I think that when you're doing the kind of thing that John was doing, where you're saying to the witness, was this fact true, and is this fact true, and so on, and then showing that logically, then you could not have said to this fellow that the sprinklers were operating. One of the things I do is when we get to the end of something like that, I say to the witness, are you comfortable with that? And follow it up with, is it the truth? And if there's the slightest pause, I say to the fellow, let's back up. Let's try this again, and let's see how much you're confident about and where your knowledge stops. This is an interesting exercise, too, in the sense that while we're trying to prepare the witness to give his facts, you're never quite sure whether you're putting things back together the way they were or in some other way. And I think the witness may be uncertain, too. And if I could use an analogy, it would be as if I suddenly swept everything off this table. And we then said, all right, let's put things back where they were. And add a bunch more objects here to make it more of a challenge. Now let's put things back where they were. And I think of it as reconstructing reality And I use that ambiguous term because I think you don't know whether you are really reconstructing reality in the sense of putting things back exactly where they were, or whether you're creating a new reality that is different from the way things were.
And then convincing them that the new placement is the truthful placement.
That's right. That's right. I guess one other thing I would add here is I think that if you're in witness preparation and you are listening to the dialogue between yourself and the witness, and you hear your own voice a lot, it's probably best to stop that because it's not going to happen that way in the deposition. And you've got to get the witness used to the idea that he or she has to take care of himself or herself.
The way I always give my self-guidance on this is that my job is to help refresh the witness's recollection and learn how to be an accurate historian through the oral testimony. A lot of witnesses have dimmed memory that we can help make sharper, and they are also not going to be instinctively an accurate speaker toward what they actually remember. So we're there to refresh their memory and to help them become an oral historian of the accuracy. What we are not there to do is to create testimony that otherwise does not exist because we think it would be strategically advantageous for the client to have better testimony than he in fact has. And a lawyer who does that is making not only the ethical mistake and the moral mistake, but is making the strategic mistake. Yes. Because what they have done is expose the witness to the challenge of credibility, and nothing is more damning to a case than when the witness's credibility has been successfully attacked. And so I would hope that this vignette is replayed by the people who are observing this and see how far you took it and the way you took it, and recognize there is a very important line that you did not cross.